Having taken a short break at the turn of the year, Crimecast.law is now back, and this is the first video case review of our new series relating to judgments published in the main law reports during the calendar year 2022. It relates to the extradition request made by the government of the United States of America in respect of Julian Assange, the founder of the Wikileaks website, on charges of obtaining and disclosing defence and national security material. On the 10th of December of 2021, the Divisional Court handed down judgment on the USA's appeal against the decision of a district judge in the Westminster Magistrates Court to discharge Mr. Assange. There was a long procedural history. As long ago as 2010, the government of Sweden had requested that Julian Assange be extradited to that country for alleged sex crimes. An extradition order was made, but Mr. Assange then appealed all the way up to the Supreme Court, which, in May of 2012, rejected his appeal, as to which see Assange and Swedish Prosecution Authority, 2012, two appeal cases 471. In the meantime, though, Mr. Assange had failed to surrender to his bail, and in June of 2012 he entered the Ecuadorian embassy, and he remained holed up there for nearly 7 years until April of 2019, when he was forcibly removed and was subsequently convicted of the Bail Act offence and sentenced to 50 weeks imprisonment. 3 of the offences for which he was wanted in Sweden became time-barred, and the Swedish prosecutor then announced that she was discontinuing the prosecution for the 4th alleged offence. However, by the time Mr. Assange had served his sentence for breaching his bail, the government of the United States of America had issued its own extradition request, and he therefore remained in custody pending the resolution of that extradition request. The allegations made against him by the USA were summarised in a document which referred to, and I quote, his complicity in illegal acts to obtain or receive voluminous databases of classified information, his agreement and attempt to obtain classified information through computer hacking, and his publishing of certain classified documents that contained the unredacted, that is to say the unedited, names of innocent people who risk their safety and freedom to provide information to the United States and its allies, including local Afghans and Iraqis, journalists, religious leaders, human rights advocates, and political dissidents from repressive regimes. End of quote. In January of 2021, after an oral hearing lasting several weeks, a district judge decided all but one of the multiplicity of issues raised by the defence in favour of the USA, but she found that Julian Assange's mental state was such that it would be oppressive to extradite him because of the harsh conditions in which he was likely to be detained and the risk of him committing suicide, and as a result she ordered that he be discharged. The USA then appealed on the grounds, amongst others, that the judge ought to have notified the requesting state, that is the USA, of her provisional view, in order to afford it the opportunity of offering assurances to the court, and that the requesting state had since provided the United Kingdom with a package of assurances in response to the judge's specific findings. In particular, there were now before the court assurances that Mr. Assange would not be subject to the highly restrictive regime of so-called special administrative measures, and that he wouldn't be imprisoned in a maximum security prison unless he were later to do something that met the tests for the imposition of those measures. There were further assurances that, if convicted, he would be transferred to Australia to serve his sentence there, and also that if he were extradited in custody, he would receive any clinical and psychological treatment recommended by a qualified clinician at the prison where he was being held. In handing down the judgment of the Divisional Court, Lord Burnett, the Lord Chief Justice, referred amongst other authorities to Kakis and Cyprus, Turner and USA, India and Ashley, USA and Giza, India and Chawla, India and Deer, and to Bacău District Court in Romania and Iancu. Lord Burnett then held as follows. Firstly, a court hearing an extradition case, whether at first instance or on appeal, had the power to receive and consider assurances whenever they were offered by a requesting state. Secondly, it was necessary to examine the reasons why the assurances had been offered at a late stage, and to consider the practicability or otherwise of the requesting state having put them forward earlier. It was also necessary to consider whether the requesting state had delayed the offer of assurances for tactical reasons, or had acted in bad faith, and if it had, that could be a factor which would affect the court's decision whether to receive those assurances. Thirdly, however, if a court were to refuse to entertain an offer of assurances solely on the ground that they've been offered at a late stage, the result might be a windfall to an alleged or convicted criminal, which would defeat the public interest in extradition. Fourthly, it was also relevant that extradition proceedings were not private law proceedings, but a process through which solemn treaty obligations were satisfied in the context of a framework which ensured that a requested person was provided with proper safeguards. Fifth, when extradition was resisted on grounds which suggested that the requested person would be exposed to conditions, for example, detention, trial, or medical facilities, which constituted a bar to extradition, but which might be remedied by suitable assurances, the requesting state ought generally to be provided with an opportunity to provide such assurances and have them tested. Sixth, a refusal to accept the assurances in the present case, on the ground that they've been offered too late, would be likely to lead only to delay and duplication of proceedings, since, if the appeal were dismissed on that basis, it would then be open to the requesting state, the USA, to make a fresh request for extradition and to put forward from the outset of those new proceedings the assurances now being offered in the present appeal, subject, of course, to any available abuse of process arguments. Seventh, and finally, since the district judge had based her decision on factual findings that there was a real risk of the requested person being subjected to special administrative measures and or being detained in a maximum security prison, and since that risk had now been excluded by the assurances provided, it followed that, had those assurances been before the district judge, she would have answered the relevant question differently, and in those circumstances she would have been bound to send the case to the Secretary of State. And so, for all those reasons, the appeal was allowed, the order discharging Mr. Assange was quashed, and the case was remitted to the Westminster Magistrates Court with a direction that it now be sent to the Home Secretary.